Hi, everybody. This is Robin Runge. I hope that the technology is working the way it needs to and that you can hear me. Um, Thank you for joining us for today's very topical webinar. And we're really thrilled to have Blaine with us, who has been directly involved in the case that led to the Attorney General's decision. And so I just want to start by thanking Blaine, and I'm going to introduce her more thoroughly in a second. I want to welcome you to the latest webinar from the section of Civil Rights and Social Justice. During the 2017-18 bar year, our goal is to rapidly respond to government action that may impact civil rights and civil liberties. So we've been a little busy, sorry. By offering free webinars, commentary, podcasts, social media, posts, and other information from subject matter experts. We encourage you to check the section website, which is www.americanbar.org and then /CRSJ. We also have a Facebook page and our Twitter handle, which is @ABA_CRSJ for more news and information and replays of our great programming. If you like our work, we invite you to become a member of the section. I really encourage you to do that. I'm a member of the council for the section, and we do phenomenal work, and I'd love to have you join us. And collaborate with us on projects you want to develop and offer our members and to the general public. During today's program, if you're so inclined, you can ask questions of Blaine, not me, because I don't have the expertise, by finding the questions box on the right-hand side panel and typing in your questions. So I'm going to pause and give everybody a minute to absorb what I just said. If you're new to GoToMeeting, it takes a minute to find the chat box, but it is over on the right-hand side toward the bottom. You may also access our PowerPoint presentation as a PDF by locating the handouts dropdown, which is in that same area. There's a PDF moniker that you might recognize. Finally, we will be sharing a recording of this program to everyone who is registered so that you can share it widely with your networks. Please feel free to leave us feedback or ask questions to follow up. I also want to say as well that a recording of this webinar will also appear on the section's website because we recognize that not everybody can drop everything with such short notice to join us for this hour, and we want to make sure that people have access to it. So in addition to forwarding the email that you receive, you can feel free to just send people to the website because this PowerPoint will appear on that website not long after this webinar. I also just need to give a shout out to the staff at the ABA Civil Rights and Social Justice section that has been working overtime to put on these rapid response webinars. I wasn't kidding when I said they've been very busy. As we all know, in the last year and a half, there have been systemic assaults on civil rights and social justice issues, and the staff, Paula and Allie in particular, have done a phenomenal job of facilitating these opportunities in a really short period of time and really identifying issues. I mean, I'll be frank, it was Paula who flagged for us that it would be great for us to find Blaine to talk with us today. So I just really, as someone who used to work at the staff at the ABA, I don't want any of us to ever forget the people who make it possible for us to do these amazing events and to learn what we need to do to interpret what's happening around us in these critical times, right? And it is a very difficult time, and there's so much going on. I know I feel barraged, right, with a crisis every day, or multiple crises every day that are human rights based, and feel overwhelmed. And so these are phenomenal opportunities to come together and really get a really deeper understanding about, wait a minute, I'm hearing conflicting things, or I'm hearing incomplete things. What really does this mean when the Attorney General makes a statement and a decision and issues actually a written opinion that so dramatically impacts decision making around the bases for obtaining asylum in the United States? Like, and how does that fit in with the broader conversations around migration and immigration that are happening today? So with that, I'm going to introduce our speaker today. Blaine Bookey is the co-legal director at the Center for Gender and Refugee Studies, which is based in San Francisco. She helps oversee strategic litigation, policy advocacy, and research on behalf of refugees and asylum seekers, as well as provision of technical assistance and training to attorneys across the country. In addition, Blaine has taught as an adjunct professor at UC Hastings and chairs the board of directors for the International Women's Rights Organization, MADRE. Prior to joining the center, Blaine served as a law clerk to the Honorable Dolores Slovater, I hope I said that right, United States Court of Appeals to the Third Circuit, and as a fellow with the Institute for Justice and Democracy in Haiti, Bureau d'Avocat International in Port-au-Prince. She's a graduate of Hastings, summa cum laude, Order of the Coif, where she was editor-in-chief of the International and Comparative Law Review, and a judicial intern at the Executive Office for Immigration Review. Before law school, she worked as an immigration paralegal for several years. She also holds an undergraduate degree in social policy and gender studies from Northwestern University, and is fluent in 4 languages: Spanish, Haitian Creole, French, and English. I'm always in awe of that. And so we're really thrilled to have you with us, Blaine, and for everyone to understand, and she's going to share with us how her organization and she personally has been directly involved in the most recent case involving a matter of AB, and how that is connected to the Attorney General's most recent pronouncement limiting protections for immigrants in the United States. So with that, I'm going to turn it over to you, Blaine. Thank you so much.
Yeah, thank you so much, Robin, Paula, for having us. It's been a crazy couple of weeks, but I think that, you know, seeing the sort of outpouring of support gives us hope that we will ultimately prevail in this case. It took us, you know, 20 years to get recognition for domestic violence survivors, and if it takes us another 20 years, we'll keep going. Just to say briefly that focus a little bit different in this webinar. We do have a webinar that's specifically for attorneys that are litigating asylum cases that dives more into the legal weeds. So I would direct people to that if there's interest. But so just really happy to make this connection with this section of the ABA. So thank you.
Great, thank you. That's a really key point, and I think maybe something to say again at the end, Blaine, you know, that if after this presentation, we do have folks who've joined us who really are at that, who are handling cases related to this and want that deeper dive, we want to make sure they have access to that. So thank you.
Yes, and we have other, for folks that maybe haven't done asylum work before but are interested, we have a whole series of other resources. So happy to share those too.
I think that's great because, you know, more than ever, I think we have lawyers who are looking for ways to contribute in concrete ways and doing more than they've ever done before. And so that's great. Thank you.
Yeah. So first, I just wanted to speak a little bit more about the Center for Gender and Refugee Studies and sort of how we, as Robin mentioned, fit into this framework and how we got involved in Miss AB's case. So our center is based at UC Hastings. We work to advance protections for asylum seekers and refugees through a variety of ways, including litigation, as well as providing technical assistance and training to attorneys to try to achieve positive outcomes in individual cases, to then also change the law on a broader scale. And our center has really been at the center for the fight for protections for women that are fleeing gender-based persecution. Our director litigated one of the first cases that I'll talk about later in the mid-90s, and then following her win in that case, had attorneys, you know, similar to today, reaching out to her all across the country saying, how can I do that in my case as well? So that was really sort of how we were founded, is on providing this kind of assistance for attorneys on how to develop these cases and win them. So before we kind of dive in to matter of AB, for those who aren't very familiar with asylum law, just provide a very basic understanding of sort of what the Attorney General's decision does and what it doesn't do. I think it's important to understand what are the legal requirements for gaining asylum here in the United States, and to just understand sort of what are the circumstances that Miss AB was fleeing and what she's up against here in the US. So what is asylum? It's available for individuals who are either in the United States or at a port of entry, as opposed to people who are coming through the overseas refugee program. It protects individuals who have a fear of persecution in their home country and or in their country of origin. And it's one of 3 that are different fear-based relief. So you might hear the Attorney General, in his opinion, also speaks about withholding of removal and what's known as relief under the Convention Against Torture. So asylum really was the focus of the decision. There's a lot of overlap between these 3 forms of what we call sort of humanitarian or fear-based relief, but asylum is the most protective of all 3 forms. It leads to permanent legal status in the United States, eventually lawful permanent residence and citizenship. It allows individuals to bring their spouse and children. They have work authorization after a certain period of time. So it's really the most protective, whereas withholding and CAT, the Convention Against Torture that I mentioned, don't lead to those permanent statuses here in the US or allow you to reunify with your family. So how does one establish asylum eligibility under US law? Just a sort of brief overview. They have to meet the definition of a refugee under US law to be granted protection. The definition of a refugee stems from the International Refugee Treaty that we signed and then codified in US law in the 1980 Refugee Act. And these are really the core requirements sort of broken out as they've been interpreted by the case law. The individual has to have a well-founded fear of persecution that is on account of one of the 5 enumerated protected grounds: race, religion, nationality, political opinion, or membership in a particular social group. And it's that last, membership in a particular social group, that we'll kind of dive more into, since that was the focus of the Attorney General's opinion and what's kind of been at the heart of the legal battle for women that are seeking protection based on gender-based persecution. And the persecution has to be perpetrated by either a government actor or a non-government entity or actor that the government is unable or unwilling to control. So it's really like a surrogate form of protection here in the US when individuals can't obtain protection in their home countries. There's also some requirements around the inability to relocate within the home country, some criminal and other bars from relief, and asylum ultimately is a discretionary form of protection. So those are kind of the basic requirements, just to better understand what the Attorney General actually did in AB. Mm-hmm. And so getting to this point of sort of what is a particular social group, there's no definition in the law, so it's been a real point of contention that's been litigated all across the country. In every federal court of appeals, has spoken somehow on this issue. And it's most important because this is really where women's claims are, for the most part, are based, is on the social group ground. And as I mentioned, really what's at the heart of the Attorney General's opinion. And there's been this kind of, in the law, a real focus on the particular social group ground, and in our view, a little bit too much of a focus. And really, we should be focusing on the other elements of the asylum definition. But really, what is a social group? If you look at it in the context of the other protected grounds, race, religion, nationality, and political opinion, it's really based on a common immutable characteristic that's really something that individuals can't change about themselves because it's something that's innate, or it's so fundamental to an individual's identity or conscience that they shouldn't be required to change that characteristic. So that's really what the social group, what the first test that came out of the board following the 1980 Refugee Act, what it said, and really should be the start of the analysis, but it's kind of become very muddied by the Board of Immigration Appeals, which is the highest sort of immigration tribunal agency body in the US, and they've grafted on these additional requirements that the group has to be socially distinct and sufficiently particular, or have particularity. And what social distinction and particularity mean are heavily debated terms, and really, in our view, are a wrong interpretation of the law, out of step with how UN High Commissioner for Refugees and other countries are interpreting the refugee definition. But that's where we are pretty much in the law, except for maybe 1-2 circuits. And that was really what we'll dive a little bit more into, that sort of what the Attorney General did here.
And if we could, Blaine, just for a second, I want to pause because this has been great, and I want to give folks an opportunity, if you have some questions on what Blaine has covered so far, kind of this groundwork. I think this is a great time to do that, because now she's going to kind of go into some more detail about the case, I think, and how we got where we are with the jurisprudence. And while people are thinking, so just a reminder, you type your question into the box over in this panel thingy on the right-hand side. This is a rare opportunity to speak to an expert and ask a question from an expert. So please, I encourage you to do so. While you're doing that, I have one, and I don't mean to put you on the spot, but I think one of the things that has really been concerning for me is the misinformation out there. I'm being generous. The misinformation being put out there about how easy it is to get asylum, right? And I would, if you happen to be able to give us some guidance a little bit about both kind of how many people apply annually, but then also like what percentage of people actually get asylum. I think that would be helpful, because I know, especially since this opinion came out, that I've been reading a lot that would lead someone to think, that this is like an open door policy, and already when you're providing us, and I wanted to ask the question now, because you're talking about what you have to prove, right? What are the criteria? And this is difficult, as you've just described, but I would love, if you could provide us with some context a little bit, right? About like, if you just any even estimates would be great.
Yeah, so there's two ways to apply for asylum in the US. There's an affirmative process for
Mhm.
individuals who are either in status or who may be crossed undetected, and or there might be an unaccompanied child. And those cases are heard by the asylum office. And then there's defensive cases for people who are placed into removal proceedings. So the grant rates at those two different bodies are slightly different. The asylum office grant rate is slightly higher than in the court, as you can imagine, where people are facing, often in detention or other sort of barriers to being able to prove their case.
Mhm.
And the national rate for the immigration courts has declined slightly, but it's it was just over 50%, and then of a grant rate, and then I think
Mhm.
nearing 50 or a little bit lower for the last year. So
Mhm.
and then you have some courts across the country where we call them asylum free zones, where they're basically denying 90+% of cases. Some judges 98% or 99% denials
Mhm.
in a year. So they basically aren't granting any cases. So yeah, as you mentioned, there's a lot of hurdles to being able to prove your case.
Mhm.
And the Attorney General actually, in his opinion in AB, actually recognizes that and says, even if you are a member of a particular social group, whatever that means, you still have to meet all of the other elements of asylum. That was the reason why your persecutor harmed you, and also that your government won't protect you. So there's kind of, there's a lot of pieces, and the evidentiary requirements. Social distinction requires, in most cases, having an expert testify in your case, is
Mhm.
basically how it's been interpreted. So yeah, it's incredibly difficult. And in terms of the numbers, so actually I'll move to the next slide too, because I think this is really
Mhm.
key with understanding why women's claims, in particular women who are fleeing gender-related persecution, why those cases have been met with so much resistance over the years. And it's kind of for several reasons, including, I'll start with the last one first because it's what you asked.
Mhm.
Is this fear of floodgates? So, by recognizing women as a social group, for example, are we now opening up our asylum system to half of the world's population? And this was a real theme in the AB decision, that domestic violence is a problem all over the world, and including here in the United States. So, is this really what our system is meant to protect from? And I think that, in our view, this is both, sort of unprincipled and unjustified. It's unprincipled because our U.S. refugee system, set up after World War II, does not have a quota system here, based for individuals here in the United States. And there's nothing in the law that says that just because a large number of people may be potentially eligible for relief, that we would somehow, that means that they should be denied protection just because there's a lot of people who are at risk. And then it's also unjustified in the sense that we have recognized, for example, cases of domestic violence since the late 90s by certain judges, and we haven't seen a huge uptick in the number of cases, including the same in Canada. Canada recognized these cases well before us, and similarly has not had a huge uptick. So it's really not, it's not a basis in the law and or fact. Um,
Yeah,
but
and so Blaine, I don't know if you see, but we do have a related question. She's first says thank you, which is very kind, for providing this helpful information. She says, you mentioned that women have been using this criteria of being a particular social group for asylum. What other social groups have used this protected ground?
So social groups, there's really been a wide range. So social groups based on gender, but also sexual orientation, gender identity. There are other clan-based groups that have been recognized. Some groups related to individual children or other individuals. So there's kind of a long list of how people have used the social group ground. And this was really, there was not a lot of guidance in the treaty preparatory language or in the U.S. refugee in the legislative history either for what this term is to mean, but it really was seen as sort of a place where people could evolve as persecution and persecutors evolve and shift and change in the world, sort of as the context changes for what people are fleeing.
Mm-hmm, mm-hmm.
And as Robin well knows, sort of at the time of the treaty, there really was, and I have some more information on this too, but just sort of, refugee law has always lagged a little bit behind the women's rights and sort of broader human rights field in the recognition sort of as the human rights field has recognized certain types of harms as human rights violations. Sort of, the adage we often hear, the women's rights are human rights. The refugee law field kind of followed suit. It took us a little bit longer to get there, but that's sort of, I think, the exact purpose of this additional category, which is to recognize human rights violations as we adopt them as a society, or recognize them as violations as such.
Mm-hmm, mm-hmm.
So
I
there's
see.
kind of these other. Oh, sorry. Mm-hmm.
No, that's
I don't
okay.
see the questions for some reason, so I'm sorry if I don't answer them.
Figure out how to do it myself, Blaine. I'm just going to be totally honest with you. I just figured it out, and I'm feeling like a new day because I couldn't see it before. There's just one other one. If you feel like you've answered that one comprehensively. The other one is just if someone is a refugee eligible to seek asylum, isn't it misleading for the government, our current administration in parens, to call such individuals illegal immigrants? And I kind of like that question because it's a broader discussion about terminology, right? Which is a great thing, I think, for us to talk about for a minute.
Sure, yeah, and I will talk about this too, also in the specific context of AB's case. It's definitely been sort of the MO of this administration to paint all asylum seekers or all immigrants currently coming here as, quote, illegals, people who are liars, gaming our system, coming for economic reasons, not for fear. And that's definitely been sort of the part of the overall strategy to undermine these claims. But in reality, individuals who are coming to the United States to seek asylum are not illegal. They have the right under international and U.S. law to seek asylum here in the United States. And actually, it really, within the law, it says that they're allowed to apply for asylum irrespective of their manner of entry. So even if their entry is, quote, illegal, they're still eligible for asylum here in the United States.
Mm-hmm. Great.
Yeah. So, these are just some other reasons why these claims have historically sort of been met with resistance. And we had kind of, as I'll in the next couple of slides show, we've kind of moved past some of these, but the Attorney General is really trying to take us back to a sort of previous outdated, antiquated understanding of women's rights. But there's been sort of this idea of, are the harms women are fleeing sort of, like female genital cutting, is that really persecution? Isn't that just a cultural practice? And, in our view, these norms or these cultural practices are, you have to look at sort of underlying them, who's putting them in place. It's most often men in the patriarchal society. And it's also the women themselves who are fleeing the persecution as something that they think is a violation of their rights. So really looking at the women as agents here. There's also this question of, in most of these cases, we've sort of historically looked at the refugee as a sort of male political dissident vis-a-vis his government. This is slightly, this is different than that sort of lens. But often, we've really, as I mentioned, come to recognize that even though women are persecuted maybe in their homes by the, quote, non-state actors, that state practices really, even if they have laws in place to protect women, that state practices actually reinforce the norms and sort of the rights of men to treat women in a particular way. And then this idea that sort of, that list of the enumerated protected grounds, gender is not one of those. So is this really what was contemplated? Yeah, or sex, yeah.
Yeah.
Was this really what was contemplated by the drafters? And isn't this just personal or criminal and, not something that's really meant for us to protect? And, again, this kind of goes to this idea of sort of what we have the women's rights movement to thank for showing us that these aren't just personal, private crimes, that these are matters of public concern. So just a bit of background. So, sort of, I've alluded to this, but, how do we get to the Attorney General's decision in AB, I think is helpful for putting the decision in context and for formulating rebuttal to the Attorney General's reasoning here. So sort of a brief history of gender asylum. The Attorney General in the AB decision really attempts to paint all of these recent developments in the domestic violence space as, too broadly interpreting the law in a very new way. But in reality, despite all of those barriers and resistance that I just mentioned, there really has been a slow and steady recognition of gender claims that's very deeply rooted in the law at this point. The board first recognized sex as one of those possible immutable characteristics that could define a social group back in 1985 in a seminal case known as Matter of Acosta. Shortly after that, even then, Judge Alito, which might be surprising to some people, cited very favorably to Acosta and recognized a social group of Iranian women and a political opinion of feminism. And even though the woman was ultimately denied asylum in that case, it was really on the facts and really clearly saw that these claims could be viable under the law. And that was in 93. And then in 96, the Board of Immigration Appeals in the Kasinga case that I mentioned recognized female genital cutting as a form of persecution and recognized a gender-defined social group of women in Togo, as women who could seek asylum on that basis. And the federal courts in dozens of cases at this point have followed suit and really recognized gender-based persecution as a viable legal theory for obtaining asylum protection here in the United States. And the only real exception to that sort of broad, consistent, steady recognition of these cases in the jurisprudence over the last 20 so years, domestic violence survivors are really the only sort of outlier to that have faced this kind of much more circuitous, very contentious route that, as I mentioned, is really based more in political concerns than it is with the objective application of all of those legal principles that I just mentioned. So if you were just objectively applying legal principles that have been recognized throughout the courts, it's not hard to see that these cases also squarely fit. But this is kind of the long sordid history, and this has been sort of what CGRS or organization has been involved in over the years. But after the board granted that Matter of Kasinga case, just a couple years later, it really refused to extend those principles to a domestic violence survivor, Rodi Alvarado, who had experienced more than a decade of incredibly brutal abuse at the hands of her husband. It was formerly in the military. But there, is a huge outcry by individuals across the United States that actually led the Attorney General, Janet Reno, in 2001 to retract that decision. The Attorney General really tries to resurrect this Rodi Alvarado decision by the board, but it's important to note that it was retracted because it's totally out of step with our current understanding of the dynamics of domestic violence and why it's inflicted.
Yeah, and if I may just highlight the connection to the role of the state, right? You alluded to this, but my memory of the facts in that case is that, as you alluded to before, she was brutally beaten and raped regularly by her husband, but she did try to seek protection from the state, right? So this is a really good example of where there were, in theory, right, it was illegal what he was doing to her. In theory, right, she should be able to seek protection from the police and from the courts. But in reality, when she did, nothing happened. In fact, because of the social construction of gender in that country and in many countries, and kind of beliefs about family and the rest of it, there was going to be no one who was going to protect her in those circumstances. And so I think that's a really important detail, and why, as you pointed out, it's strange that victims of domestic violence have been an outlier in the jurisprudence, right? Because clearly there is a clear state actor here, right? Which is in a human rights framework, and she has a right to be free from violence in her home, and she has a right to be free from intimate partner violence. But the systems and the laws that were in place to provide her protection were in fact placing her at greater risk, right? Because if she relied on those to provide her with protection, it could mean that she was going to be killed, right? Because no one was going to come in and help her. So I just wanted to make that connection.
Yeah, thanks so much. Yeah, that's exactly right. And in Rodi's case, I think her background and her decision to leave, I think, also show just sort of very similar to the circumstances of Miss AB's case,
yes.
Where she left children behind with whom she still has an estranged relationship after all of these years. So it was a very incredibly anguishing decision to actually leave the country. So there's, the administration tries to paint these individuals as folks who are just trying to come here to, seek a better life and game our system, when in reality, most people don't want to leave everything behind unless they are truly fearful. So yeah, so Rhodey's case had this long history and eventually resulted in a grant of asylum to her more than 10 years after she first applied, but it was a non-precedential decision because the board had sort of sent it back to the immigration court level, and so it didn't have a lot of binding effect on other adjudicators. But the documents developed through her case, including the position that the Department of Homeland Security took in 2004, really set forth what the legal theories are. And DHS in that 2004 in their briefing specifically said that domestic violence survivors can be eligible if they meet all the legal requirements, and set forth some of the possible social groups and legal theories on which these cases can rely. And the DHS has consistently taken that position throughout the years, including this well-known matter of LR case. They filed a brief on their official position in 2009, and then again, even in Miss AB's case, continue to adhere to that position that these cases can be viable in the right circumstances. The Attorney General tries to admonish his sister agency for making those, what he considers to be improper sorts of concessions, but really, it was a very considered approach to the law over all these years. So, eventually, the mess in Rhody Alvarado's case led to the Attorney General finally lifting there had been a stay on the board from issuing a decision in a domestic violence case for many years. So all those cases were held either in legal limbo at the board, or judges were actually granting them at the lower levels. So even though we didn't have binding precedent, judges were looking to those other analogous cases in the other gender framework for granting domestic violence cases really across the country. And then finally, in 2014, the board issued a decision that really tracked the position that DHS had been taking in these cases over the years. It very firmly, finally recognized that domestic violence may be a basic basis for asylum, and which, that's an important principle itself, because there were some judges who were categorically denying these cases, saying this really isn't what our asylum law is for. But the actual legal holding of matter of ARCG is really limited. It only looked at whether the particular social group that had been advanced in that case, married women in Guatemala who are unable to leave their relationship, looked at whether that social group itself could meet this three-part test of immutability, social distinction, and particularity. Yeah, so it's it's
really narrow.
Really narrow. So it's a very, very good decision for this sort of overall overarching principle, but it's what it actually held is quite limited. And ARCG itself didn't set any sort of categorical rule that these cases should always be granted. They still have to be evaluated on the facts of each case. It's a well-established principle in asylum law that cases are adjudicated on a case-by-case, record-specific basis. So, just as a negative case doesn't mean that these cases are foreclosed, a positive case doesn't automatically mean that everybody's in. And ARCG itself, because it's a limited sort of narrow holding, there was a lot of confusion following it of exactly how far it should extend or how these cases, should be granted. But the confusion now that the Attorney General retracted ARCG and issued this, really poorly written decision in AB, poorly reasoned as well. I think it's just plunged us even further into total confusion. So we can dive into what so it's kind of with all of that as the background, and what is the AB case, and you'll see there's kind of a lot of similarities actually in AB's case with some of the previous cases like Rhody Alvarado's case. Sort of who is Miss AB? She's a 47-year-old woman from El Salvador. She was orphaned during the Civil War. She lost her father, and then shortly thereafter, her mother was in a fatal accident. She was abused as a child with a family that took her in. She met a man in her early 20s who she later married and had 3 children with. The abuse started very early in the marriage. It was incredibly vicious. Repeated beatings, rapes, humiliation, belittling of her, and several death threats, including threatening to hang her from the ceiling by a rope, putting knives to her neck, pointing a gun at her head. She tried to move away from him a couple of hours within El Salvador, but he followed her, found her, continued to attack her. And again, like Rhodey, she tried to report to the police, but the police issued protective orders. El Salvador, like many of the Central American countries, has a framework law on violence against women, but they actually made her deliver one of the protective orders directly to her abuser, alone, not with the police, which obviously put her in, even more danger. And her husband was actually married. His brother was a police officer, so her brother-in-law was a police officer, and he also was involved in threatening her. She even divorced him, but this only escalated his threats, and to the point where she really feared for her life. So that's why she ended up coming to the U.S. and leaving behind her 3 children, who are still at risk from abuse by the husband. She crossed the U.S. border and she claimed a fear to Border Patrol, and they found her to have a credible fear. And then she bonded out and was unfortunately moved to the Carolinas, where her case was in the Charlotte, North Carolina district, where she ended up with an immigration judge, Stuart Couch, who's known as incredibly hostile, not just to all asylum seekers, but in particular Central Americans, and within that, in particular, Central American women fleeing gender persecution. This judge has more than 90% denial rate. He found her he didn't believe her, and he also rejected her legal arguments, but this did not withstand appeal. So the Board of Immigration Appeals reversed and sent back with instructions for this judge to grant her asylum after she passed her fingerprint check, her clearance. But the judge, in a very, out of step with normal practice, attempted to what he calls recertify her case back to the board, saying that he thought that ARCG was no longer good law under a Fourth Circuit case that had come down, which really actually said that ARCG was an opposite to the case before the Fourth Circuit. But so it's really weird, sort of procedurally irregular, sort of what happened to her, how the judge sent it back, and how the case came to the attention of the Attorney General. There's some, emails between Judge Couch and the director of the Executive Office of Immigration Review, that may be untoward, and there's, some irregularities around how the Attorney General, came to know about this case and tried to certify it to himself. So he took the case and he issued this public call for amicus briefs on a question of whether victims of private criminal activity can be a particular social group. Even though this wasn't the social group advanced in her case, it's very confusing. It seems to muddy all of these elements of asylum, including the nexus requirement, the state action requirement, the social group, but Miss AB, we came in as counsel for Miss AB once this public call came out. After that, both Miss AB as well as the Department of Homeland Security asked the Attorney General to clarify his question and to give us notice of which cases were potentially under his consideration for vacature, and he refused to clarify the question or tell us which cases he was considering overruling. But so what did the Attorney General eventually do? So he really accomplished 2 objectives through the AB decision. The first was to reverse the grant of asylum to our client, Miss AB, and the second was to use her case as a vehicle for overruling the ARCG precedent. Even though both parties, Miss AB and DHS, plus 11 out of the 12 amicus parties, urged him not to do this. He really uses the case as his decision to cast doubt on the viability of domestic violence claims generally, and to bully adjudicators into prejudging these cases before having considered any of the facts or the evidence. However, under a close reading of the law and our interpretation of his decision, he does not foreclose these cases as a categorical matter, which he really can't do because he is adhering to the longstanding principle, as I mentioned, that asylum cases are to be considered on a case-by-case basis. And in fact, much of the Attorney General's decision is actually factually based. It's factual in nature, not legal, though he has very little citation to the actual facts. But he doesn't change the basic asylum framework that you have to establish a well-founded fear of persecution on account of a protected ground that the government is unable or unwilling to protect you from. So he really didn't change the legal the overall legal framework. He sort of took away this good decision that we had in the ARCG, but as I mentioned, ARCG itself, good decision, but didn't hold much. So we're kind of, in our view, we're just kind of back to the pre-ARCG world where we were looking to analogous case law for how to analyze these cases. And the U.S. Citizenship and Immigration Services, which oversees all of the asylum officers that are that adjudicate the affirmative cases that I mentioned, as well as that oversee the credible fear and reasonable fear process, which is in the expedited removal context. So individuals who are recent border crossers who are placed through the expedited processing, and USCIS interim guidance, really supports our position that you can't cite to ARCG anymore, but doesn't say anything about these cases being totally foreclosed.
And Blaine, just to clarify for everybody, the interim guidance that you're referencing was just released this week. Is that right? That yesterday or the day before? So this was something that's available, I believe, on the DOJ's website. I've seen it cited to in news media with a link, and I've clicked on it and been able to go to it. So this is a publicly released document. And as you point out, it's interim guidance, and this is sub-regulatory. So just to be really clear about what we're talking about, right? This is something that is intended to provide guidance to the individual adjudicators in these cases, pending a further analysis internally of the meaning of the Attorney General's opinion. So that's the interim concept, right? So that also flags for us that we can anticipate that internally they are going to issue further guidance in the future. And so that provides possibly an opportunity for advocacy. But I just want to clarify, for a moment, and it is public, right? So it's interesting to think about, citing to it in other contexts.
Yeah, that's right. And the USCIS guidance is not binding on immigration judges or the board or the federal courts, but because they are the expert agency on asylum, that often it can be persuasive for how to interpret the refugee definition. But so I think the important sort of messaging point for us is that these cases really, on an appropriate read of the law, should not be foreclosed. That doesn't mean that some adjudicators won't read it in that way, especially with all of the Attorney General's sort of encouragement to read it that way, even though it's not actually what it holds. We've already seen at least one decision out of the board that does semi-interpret it that way, and we think that case will be hopefully overturned. But it's so we're not, I guess, Pollyannish about what the potential incredibly negative impacts the decision could have on individuals, especially in that expedited credible fear processing, where there's very little judicial review of those decisions. So, there will be a fallout from this decision, but they really shouldn't foreclose these claims.
Yeah, so I think the last point on this slide is the most critical for this audience. And again, I think this is a really good example of where the quick pickup in the media, right? The headlines made it seem like it's now impossible for victims of domestic violence to seek, frankly, you could argue, and then obtain, right, asylum in the United States as a result of this opinion. And what you're helping us understand is that's not true. It's made it more difficult, but that and we're not even talking about the other piece, right? He didn't only talk about domestic violence victims, right? He talked about people fleeing gang violence. And I would assume that the same analysis applies there, that this is not making those claims foreclosed, it just makes it more difficult.
Yeah, and I have some of the dicta on his, on what he talks about for other types of cases, which on one of the later slides, which I can show.
Someone's asking you just really quickly, you mentioned that one case had just recently come out of the Board of Immigration Appeals, and someone's asking what the name of that case is, if you have it.
Yeah, it's actually it's unpublished decision, like the vast majority of board decisions. So it's not, I don't even think you would be able to find it on Westlaw or Lexis.
And that also means it's not precedential, right?
Yeah, it's not precedential, no.
Okay.
No. Yeah.
Okay, sorry, just wanted, that was so
and a single board member, not a panel, yeah.
Okay, that's good, a single board member, not a panel. Okay, great.
Yeah, so even more. Yeah, so,
this is actually a question I've had as well. Someone's asking, how did the matter of AB have any how did Sessions get it? Like, can he just do that? Sorry. And then separately, how did the matter of AB have any standing for Sessions to issue guidance on gang violence? Like, how did he use that as a way to kind of, make these pronouncements about both these categories of asylum seekers?
Yeah, so I mean, the Attorney General takes a very broad view of his power under the regulations. We did raise a jurisdictional challenge to the Attorney General's his certification of this case to himself.
Mhm.
Our view of the regs is that he really can only take cases that are currently pending at the Board of Immigration Appeals. And in this case, because the Attorney General actually agrees with us that the immigration judge never actually sent the case back properly to the board, and really the scope of the remand from the board in this case was to grant asylum if clearance checked, and the judge didn't do that. And that never issued opinion, never got back to the board. So how the Attorney General actually found out about this decision is still, and we have a FOIA out to DOJ on this, trying to find out sort of how her case, what some possible due process and other procedural irregularities. But the Attorney General does have broad powers to certify cases to himself when they're pending at the board. There's still some potential challenges to sort of his overreach and whether his decision, the level of deference that the federal court should give to it. So anyway, yeah, that's kind of, how he got the case. He has, there's some possible communication with how he found out that this case was pending. We know he even as a senator took, pretty strong positions against gender-based persecution as a basis for asylum, and really, held hearings on it. And, so he, even as a senator, so we, kind of knew that this was on his radar, that he was going to find a case. Miss
Right.
AB's case has nothing to do with gang violence. It also has nothing to do with family-based persecution, which he, dropped a gratuitous footnote to trying to call those into question. So in our view, those statements, which aren't even in the opinion section, I think they're in the background section, are dicta. And even so, the same sort of argument would apply, that these cases, all of the cases are to be adjudicated on a case-by-case basis,
Mhm.
and with the record that's before the particular adjudicator. But it's again to send a message to judges that they should be rejecting these cases, and to the asylum officers and border officers that they should not be recognizing these cases as viable, and to send a deterrent message to individuals to not come here, to say that they're not eligible for
So what you're
protection.
saying is there's no requirement that that case even mention gang violence in order for him to mention it in his opinion. That's basically what you're saying.
Yeah,
Um,
that there's some argumentation around the impropriety of addressing issues that were never fully given any consideration
right.
by the
Not
agency below,
brief,
or they
nothing.
had no chance to brief or anything. Yeah, exactly.
Yeah. Okay. And then two related procedural questions.
Yeah.
Can the Attorney General's opinion in AB be appealed? And will the outcome of the case impact claims of LGBTQ asylum seekers?
Yeah, so in terms, I'll first for LGBTQ asylum seekers, I'll go back to this slide. So there is some concern around the Attorney General's articulation of the state action, the state protection standard. There,
Mhm.
as I've said a few times, the standard really is whether the government is unable or unwilling to protect. And he, in his opinion, uses some language like condoning, whether the government condoned the abuse, or and then also this language of that they demonstrated a quote complete helplessness to protect. That there's some that's coming from a couple of there's coming from a Seventh Circuit case, and the Eighth Circuit has used that language most. But in reality, and that could influence, if that's viewed as a change in the standard from the unable or unwilling in LGBTQ cases, which are often perpetrated by non-state actors, that could have some potential negative impact in those cases. But really, our view of this language is that it doesn't shift the standard, and in fact it really couldn't, because the statute only requires that an individual have a well-founded fear, not that they have 100% fear that they would be persecuted without government protection. So there's some arguments, and even the cases that use that complete helplessness language are not actually applying it in that kind of a way, where they're requiring 100%. Even in the case that the Attorney General cites, the police did take some action for that individual. And that's obviously wouldn't show that the government was completely helpless.
Mhm.
Anyway, there's definitely a lot of arguments why it shouldn't. But I think that's probably the most, that place in the Attorney General's opinion is probably the most concerning for people who are for other non-state actor cases. even though they weren't, explicitly called out in the opinion itself.
Mm-hmm. Mm-hmm.
Yeah. Um, and then I guess another piece, is his credibility analysis. Sort of
Right.
he reversed the board's finding of credibility of Miss AB, based on just a few omissions and inconsistent statements. He calls out sort of what she had said at the border as undermining the veracity of her statements, that she, quote, came to work, sort of, and this is a recurring theme in a lot of these cases where the border notes say that a person said that they came to work. There's been several studies, including funded by the government, that have actually shown significant, there's a lot of unreliability to these notes and abuses in the border process. And Miss AB's case itself, she actually, if you look at the actual record, the notes actually have a stamp on them saying that the witness refused to sign them. And her testimony has been that she didn't know what they said because they were in English, so she wasn't going to sign something. So, and they even referred her for a credible fear process anyway. So, the fact that that she might have said that, there was obviously some indicator that she had a fear of going back. Otherwise, she wouldn't have been referred for a credible fear interview. But I think, just sort of how his analysis and credibility, and this, I don't have a slide on this, but they also have this another sort of footnote on the discretionary element of asylum, that really adjudicators are glossing over this requirement too much, and they should be really, even if so if he can't get around the eligibility requirement, which maybe he's foreshadowing that he can't, that these cases still are going to meet the eligibility requirements, that judges should somehow still deny them in the exercise of discretion, by looking to the manner of entry of the individual. And he really mischaracterizes the case law here, that an individual's manner of entry alone should be dispositive of whether they're given discretionary grant. The case law actually says that would, only the most egregious factors should really outweigh the risk of persecution to an individual.
Mm-hmm.
So there's all these little nuggets in there that I think we have to watch out for how adjudicators are going to see them. But again, they're not clear legal holdings, and in our view, they don't actually change the legal standards. So if judges are really looking to the existing legal standards and are fairly applying the law, and which we hope the federal courts would overturn if they don't, then people should still be able to prevail in these cases.
Yeah.
But again, that's in the years before ARCG, we had you have some adjudicators that fairly apply the law and some adjudicators who don't. And even actually after ARCG, same thing. You have the judges who are denying 90+% of cases, and I don't foresee this decision really making a huge impact on their denial rates.
Yeah.
So, and these are the quotes that people have sort of looked to, in a concerning way, that, generally these claims should not qualify for asylum, and he's saying that really based on nothing. He cites to no actual facts. In Miss AB's case, which was, we had submitted over 700 pages of additional supplemental documentation, nowhere cites to, one piece of that. And this idea that there's a reason to doubt that a nuclear family can be a social group totally flies in the face of all of the weight of the jurisprudence, which totally and utterly has recognized families as social groups for years. So we're not that concerned that it would have a shift. And again, it's in our view dicta, because she didn't raise a family claim. Mm-hmm. So, some of the next steps, somebody had mentioned sort of what's next for Miss AB. So we're still, figuring out our legal strategy in her case. There are some jurisdictional bars in the asylum context or in the immigration context, which may foreclose the ability of a direct appeal in her case, but we're still considering all possible options in her case. I think one important thing to note is that, and I should just note that the Attorney General, in his order, sent her case back to the Immigration Court for consideration of withholding and the Convention Against Torture claims. And in our view, also the asylum claim would still be open, especially given all of the new evidence that was submitted. But so, it's not the end of the road for Miss AB. Mm-hmm. But I think that, it's important for us when we're thinking about challenging the Attorney General's opinion to really look at this, as I think Robin started, as you started this, that we're looking at in the context of the administration's, all-out onslaught against asylum seekers seeking to close our borders to them. And this is kind of the third step in the process. So they've done a lot of things to try to limit access to our territory, to our asylum system at all, by turning people back at the border, separating families, forcing people to give up their claims, or even if people are shuttled into the system, curtailing their due process rights within the system by putting them in detention, taking away funding for counsel, or limiting access to counsel so people have a difficult time actually proving their cases. And then finally, even if you get to court and you have the ability to document your case, trying to find ways to roll back substantive asylum law so that individuals are still denied. So this is really for us sort of just the continuation of the process of this administration, the overall strategy to foreclose relief and deter individuals from coming to the United States. So I think that for us, this is part of the broader challenge to push back to all of those policies. And I'll just mention that even if we direct appeal Miss AB's case, depending on the outcome, it may only apply to cases in the Fourth Circuit, whatever decision comes out of the Fourth Circuit, which is where her case arises. So we're looking for other cases that are challenging the Attorney General's decision in AB in all of the various circuits. So this might be cases that were already pending, or cases that will soon be denied by the board and will end up in the federal courts of appeals. So we're tracking some of those cases, and then also tracking some of the denials at the lower levels to start developing materials to show just sort of what the impact of the decision, not just in domestic violence cases, but as people have raised, astutely, some possibly gang cases or LGBT cases or any other range of private actor cases to sort of see how this has been negatively impacting individuals.
And yeah, so this is really helpful because one of the questions that you got was, or if you're aware of anybody relying on this opinion yet in any decisions. And I mean, it's been like a week, but
yeah, we have the only case we've seen there's only seen one case out of the board. Obviously, we've been tracking these cases for years, and we do have attorneys. We give assistance in 6,000 or something cases a year at this point. So we are seeing a lot of the cases, but we're not seeing all of them. So there may be other ones out there that we just haven't been made aware of yet. So in addition to the legal side of trying to push back, you'll recall that this brief discussion about matter of RA and how really public outcry led the Attorney General to revoke the board's decision. We're also working on that front to educate the public and members of Congress about this decision and its potential negative impact and how it's really out of step with our understanding of women's rights at this point in our country. So we have a toolkit, which the link is there, and the toolkit will be continually updated as new actions come to light. And we will be having a national coordinating call for advocates who are interested in this non-legal side. So stand by for that. You can sign up for our listserv or check back on our website to be in the loop on that. But the ultimate ask is to push for the Attorney General to revoke his legally and factually flawed decisions. That's really the main goal of the non-legal advocacy, as well as to, as I mentioned, educate the overall public, but also to sort of educate adjudicators as well, start educating them, as the cases are sort of wending their way through the system. And then for individuals who are representing asylum seekers, we provide litigation support. So we have sample submissions, sample briefing, and we'll be updating all of our resources, as we can in the wake of AB. And you can request that through our website there, or if you've already requested assistance in a case a while ago and you want to talk with us about any potential strategies now, like seeking remand in your case, or any of the other issues, sort of how to address the fallout of AB, you can just email us at that address there. This is, just end by saying that this is really with the wins in individual cases across the country, what kind of jurisprudence from the bottom up, I guess, is it really has, I think, was a huge part of what got us to ARCG, and I think will get us to another ARCG in the future, is by having immigration judges consistently recognizing these cases across the country. So the individual wins are incredibly important part of the overall strategy.
Well, thank you. And look at that. It's exactly 2 o'clock. That's impressive, Blaine, I have to say. So I want to thank you again for taking the time. I know, well, I don't know, but I can only imagine how extremely busy you've been in the last week, with inquiries, I'm sure, from individual attorneys. I know you shared with us that you've been participating in similar webinars like this. And so I really appreciate you taking your time to be with us and answer questions. I know there are a few more questions here that we didn't get to, and we'll make sure to follow up because I want to be respectful of your time and of everybody who's joined us. I just want to remind everyone that there is a PDF that's attached over on the right as a handout, and that PDF is the PowerPoint slides with all the links and the citations that Blaine has provided to us today. In addition, this webinar is being recorded, will be sent to each of you individually, so you can forward that to anyone else whom you think would find this helpful. And then it will also be placed on the ABA's Civil Rights and Social Justice Section's website, so that other people can access it that way if for whatever reason you can't find this email when you meet someone who you're like, oh, you really need to see this. So thank you for all that you're doing, Blaine, in these difficult times. I know that I appreciate so much the work you've done previously, but in this moment, we need individuals like you even more than we've ever needed them before. So I just really thank you and encourage anyone who's interested in getting involved to please reach out to Blaine. All the contact information on this last slide about technical assistance. I want to say, and Blaine and I talked a little bit about this before the webinar, I was around in the INRI RA days and was heavily involved in those outreach efforts and education efforts because there was a changing of administrations at that time as well that we utilized, I think, to a certain degree to our benefit, but never underestimate the power of outrage as we're seeing every day. And so really supporting the non-legal, for lack of a better description, advocacy mechanisms that are being put together by Blaine and others is really critical in addition to handling individual cases. And I want to say something about that, which I had not really thought about, but it makes sense. I think in this area of law in particular, that's not the case in a lot of areas of law, right? Where every individual case matters in opinions, and not so much because of precedential value in the traditional sense, but as you're pointing out, a tipping point, right? Yeah. A tipping point that gets us to that opinion that brings us back to where we were 2 weeks ago. And we have lost ground today. So thank you again. And I'm going to just shout out to Paula to make sure I'm not forgetting anything really important in the context of technology or anything else.
Nope, you were wonderful. Thank you so much, Blaine, and thank you, Robin. This was absolutely fantastic. I know I learned a lot, and we're just thrilled that you could join us. So thank you.
Yeah. Thanks
Thank
again for
you,
having me.
Paula.
All
All
right.
right, bye.